verdicts that sometimes are head scratches, sometimes are not necessarily so. Now, from tribunal judgments in most parts of the country, we've seen some of those results that have been accepted by the people, and some of those that have been challenged also, whether it's the Presidential Election Petitions Court or the National Assembly Election Petition Tribunal, as well as the Gubernatorial Election Petition Tribunal. Just 24 hours ago, Kano and Bauchi State were waiting in the wings for their own verdicts to come through. In Bauchi State, it was an affirmation of the victory of the incumbent governor who has won his re-election bid, even though the APC disagrees with that ruling. But in Kano, the biggest upset so far as the tribunals are concerned, with the tribunal overturning the victory of Governor Abba Yusuf, ordering INEC to now give a certificate of return to APC's Gawuna, who they say, after recalculating the votes, is the winner of the March 18 gubernatorial election in Kano State. So we're going to unpack some of these developments today, and join us is a legal mind who understands tribunals, has won a fair share of his own petitions also in court. So maybe he will reflect on some of the victories he has had and some of the failures in some of his petitions also. SAN Okabwe is joining us on the program. Dr. Sam, thank you very much for coming on the program. We really do appreciate you very much for coming on Daybreak this morning. Thank you very much for joining us.
Thank you very much for having me.
Right. First of all, initial impression. Tomorrow, September 22nd, the tribunals the time would have elapsed for the National Assembly Election Petition Tribunal. I know the Gubernatorial Election Petition Tribunal will have up until October 11, I think, before time runs out, as far as the provisions are concerned. Let me just get your overview on how the tribunals have fared, the judgments, and what is your overall take on how things are shaping up?
Well, you know, we all have to be tentative for now, because this is the first round. The second round is on appeal. You know, you've had judgments here and there, and APC is having its day some other places, PDP is having its day some other places. I think the only party that I think is not having it too well out there is perhaps the Labour Party. You know, some of their candidates have been disqualified, you know, and their election nullified on the basis of whatever. But at this stage, yes, you know, like you said, time is running off for most of the National Assembly election petitions, but those ones that came later after the what you would call the rerun, you know, those ones are still they still have time, and even for the governorship elections, some still have time, but basically before the end, by early October, would have been done with this first phase. And at this point and at this stage, judgments turn on facts and evidence. If you have the evidence in support of your case, you have your day. If you don't, you're damnified. Sometimes too, there is the human angle. The judges can err, as we say, in the assessment of the evidence and the value they give to the evidence. And, basically, in terms of the principles, except for a few occasions, the principles are there, clear, and easily understandable. But how do you attach the facts to those principles to make your own verdict, your own judgment, is usually the problem on appeal. Because on appeal, I would say, if I'm allowed to say so, the person who will be on trial would be the judges, the three-man panels. Yeah, the appellate courts are going to assess your understanding of the case, your assessment of the evidence, your analysis, the quality of the analysis you made, and the findings and judgments you made. If you err, of course, that will be a reversal. You know, so for most of them, one does not have the opportunity of reading the judgment for it to be very conclusive. You know, in the case of the presidential, we all listen to the judgment from the beginning to the end, and you have a very fair share of what the issues were and the findings of the Court of Appeal. So that was why people like us could say, oh, we make these very near absolute predictions that, oh, if it gets to this, this is what it is. But for now, let's be tentative. And I don't see any cause for worry for any of the parties for now. Yeah, for now, yeah, those who have lost, they have the burden of compiling records and pushing the case to the appellate court.
I would say I would rather win in first and second rounds, you know, than to lose the first round and then win the second round.
What if you win the first and second and lose the third one?
Right,
That's
okay.
Bad.
So
Yeah.
just to sum it up with the National Assembly Election Petition Tribunal itself, one particular thought kept permeating public debate, and that is the consistent inconsistencies in the judgments, where in some of the cases the victors announced because the petitions were dismissed as pre-election matters, and in some cases again the victors were announced because the petitions were upheld as, you know, as valid, even though they were pre-election matters, for instance. What is your understanding of it, and is there something that Nigerians don't understand about how certain pre-election matters could still remain valid during the petitions, during the tribunals?
No pre-election matter will be valid during the election. But like I said, every judgment turns on the facts of the case and the evidence adduced. If the issues are pre-election issues, they should have no business with the election tribunal. And if some tribunals err in upholding the cases of the petitioners in respect of matters that were pre-election,
You're saying it's black and white, open and shut?
I'm certain that those judgments will be reversed on appeal, you know.
But during the Presidential Election Petition Tribunal, we also heard the judges saying that this matter is not valid at this point because they are pre-election matters.
Yeah, that's what I'm saying. What are the pre-election matters? Issues that border on nomination and party sponsorship.
Qualification.
You know, no, not all of qualification.
Okay.
You know, qualification is a very wide ambit, you know.
Maybe help us unpack that, because I think in just, for instance...
the issue of qualification is a very wide and a very delicate one. Here is what constitutes a pre-election in respect of qualification. If what you are challenging is on the basis of the form that the candidate you are challenging presented to INEC, the form EC9, and that form is where you make your declaration in respect of what? Your own qualification. There are areas you have to tick and all of that, and at the end of the day, you swear to an oath that all that you've stated is true and that you are qualified. You know, you would have supplied your biodata, your educational qualification and all of that. If you are making a case out of that form, it's a pre-election matter, because Section 29 of the Electoral Act has stipulated that when INEC publishes the name, of course it's going to publish the name together with the declaration of the candidate that is qualified. You have 14 days to challenge whatever declaration he has made in that form. You know, you have 14 days with you to do that. If you sit on that right, you don't, you wait for the election. Just like what happened at the presidential.
It started bad?
It started bad. You know, and when something is started bad, irrespective of its merits,
right,
the issue is, they say you can't even open it.
Right.
say, oh, this book, whatever it is, whether it's a grade A or a fantastic.
That is after the fact.
This doesn't matter. It doesn't count. You know, there is a bar, a legal bar for you to attend to it. You know, so those are the other issues. But if your contention has nothing to do with the form, then of course the tribunal can hear it. And if you also have the fact that a court has already disqualified somebody during the pre-election matter, and the person still went ahead to contest anyone, you are going to bring that fact to say, oh, he has been disqualified. And because he has been disqualified by a court, he is therefore, on the day of the election, not qualified. And therefore, all the votes that he had...
What about petitions built on party internal affairs, like...
No, those ones are... I don't know if
I mean, in just, for instance, here's the question. In just, for instance, the petitioners were trying to prove that the PDP does not have a legitimate structure that could produce a candidate in the election. And that is why the tribunal nullified
it's
the victory.
You see, some of these propositions, on the face of them, they look ridiculous. So it's like I would always do, I'll be tentative about it. I will need to see the facts. But if what you are saying in the proposition, that proposition is wrong, because it's internal party matters, even for members of the parties themselves.
Because in Kano, we also hear that he was not a registered member of the party. Are things like this still valid? You know?
Well, yeah, the Constitution says for you to be qualified, you must belong to a political party and you are sponsored by that political party. That's a constitutional requirement. If, on the other hand, I know that you are not a member of a political party that sponsored you or supposedly sponsored you, I could make that case. But if I'm to play the devil's advocate, what the heck? A party has already presented a candidate.
How could he not be a member?
What better evidence do you have for membership? Does the membership, except if you are telling me that membership has its timelines, he must have been a member between this time. But if...
Does it matter if he's if he's on the register of the party or not? If the party submits its register of members to INEC and his name is not there,
then it becomes an issue. You shut yourself up.
Are that classified as pre-election matters?
Because if the party presents its own register, you understand, and mind you, the register does not form part of the Form EC9. So it's not one you could say, oh, it's a pre-election matter. The content of Form EC9 that constitutes the Act has said you must litigate within this period. But on the register of a party, if I go through, you have already published to the world and made a categorical statement that this is the list of my members. Here are my members. And I've gone through that and did not find the name of the candidate is sponsored. I can make a case to say, no, this person is not your own member. Because by your own showing, his name is not there. You have published to the world that these are your members. You understand? But like I'm saying, these are all factual issues.
And does the statute of limitation also apply here in terms of when you could make that case?
No, that's what I'm saying. No, it's not, because it does not form part of the Form EC9.
So the issue of statute part does not come in at this point?
No, it does not. It should not come in.
Dr. Sam, we've seen how the Election Petition Tribunal has been evolving, and one thing that people cannot take away from all of this since it started is the deployment of technology. We saw that the presidential election, you know, there was a live broadcast, which has never happened before. And then that,
there have been some broadcast
of the presidential.
Okay, for the presidential.
Tribunal.
Okay,
that's what I meant.
Yeah, I think in 2019, as part of it, maybe it didn't just go as viral as this one. This one, I think it's because they had already created the narrative that all eyes on the judiciary. I think
true, all eyes on the judiciary.
Yeah,
everybody was beaming their searchlight to know what happens, and we didn't want to hear that something happened in court, and we got all of the dramas. That's good. But coming to Kano now, we saw that the proceedings, of course, the judges were not in Kano. They had to do all of the judgment and reading out all of everything they had to read and taking notes and everything virtually. Is that a ground for, the opposition now, maybe somebody who is agitated, to go to court and say, this doesn't stand? Because from what we got, there was some kind of glitches yesterday during the proceedings.
Okay, you want to say that by itself nullifies or voids.
Could it be a mistrial?
No, not mistrial. It voids the judgment. That the judgment should be delivered in public.
Yeah.
Is that what you're saying? Well, I do not think that would be a very strong ground. You could make it a ground, but I don't think it's strong because
he doesn't think it breach any justice administration protocols.
What are you breaching? Somebody, the COVID protocols had introduced virtual court proceedings and delivery of rulings and judgments. So I don't know whether the present rules.
Clearly we don't have a public health emergency at this moment.
When they provided for that, but even if they do, I do not see where it would void the judgment. The judgment, as long as it's delivered by the people who wrote it and signed, what constitutes public delivery.
But anybody could have said that something, maybe anything could have happened during when they had the glitches.
Somebody put a gun on them.
That's a possibility.
Well, it's for you to prove, but I do not think that will constitute serious. The issue there is whether or not that judgment is valid. And I'm saying, well, it could be, if you ask me if I'm to be on the appellate list, I would say it's valid. But let's allow them do their job.
From your experience, working on legal teams, making a case, how does this review work exactly, and what would the appellate court be looking for in some of these judgments that people see as controversial or scandalous? What do they look out for? Because not many of them end up getting overturned. We've seen quite a few most recently. I think Oshun comes to mind, which has some similarity with what happened in Kano. But before we get to the details, let's understand what goes into the appeal from the tribunal.
When a judgment is made, the parties have the right to challenge the reasoning of the court. That is, their findings and their decisions. The findings constitute analysis of the evidence. You take a look at the evidence of the parties, their case, their arguments, and you say, I believe this, I don't believe this, this is my own findings. If I believe that your findings are wrong, or I believe that the way you analyze the evidence is wrong, or if I believe that, yes, your finding is right, your analysis is right, but your conclusion is wrong, I'm going to make it a ground. For each one of those areas or parts of your own judgment that I believe does not conform with the law, I make it a ground. Those are the grounds. That's why you see one of them at the presidential having 51 or so, the other 30-something, and all of that. Those grounds are errors that they believe the trial court has committed in the judgment. So it is those grounds that they are going to now put all together and generate issues for argument. The issues will now be, like for an example, was the tribunal right to have held that this constitutes a pre-election matter? You understand? That is an issue you are going to ask and argue. You now make your own argument to say, by virtue of this line of appellate reasoning, these cases, A versus B, C versus B, decided in this by the Court of Appeal and the Supreme Court, especially the Supreme Court, you would think that this particular decision is wrong. The other person will counter. He will also say, oh no, because all the respondents, those who benefited from the judgment, or those who you appealed against, have the duty to defend the judgment. Right. They will not have to defend the judgment, although some of that point, some other person can concede. They say, okay, I'm not going to argue against this thing, but I will concede to the appeal. Right. Full stop. Okay. You understand? So this is how it works. Then the appellate court is now going to look at the evidence, the case of the parties as presented, the evidence adduced, how it was analyzed, how the decisions were read, and make its own findings and decisions as well. It's like a supervisor marking an examiner. It's
I don't know how whether you're a football person, but it's just like having VAR. When the referee says it's penalty, they have to look at it elsewhere and say, listen, we don't think this is penalty. Go and take a look at the monitor.
Meanwhile, whereas they will still defer to the
referee. In this case,
but
no.
The judges, they overrule you.
Okay, let's juxtapose two similar cases, which I think many people will still remember. The Oshun case happened just last year, where the tribunal, even though there was a minority report in that judgment, which makes it different from the Kano situation, where the tribunal pretty much recalculated the election tally itself and said, you know, these votes are invalid, so we're going to do the maths again. And Mr. Adeleke, you're no longer the winner. It's the former governor that should be given certificate of return. This has happened before. For some people, this is the same argument with Kano. However, what we understand is that in Osun State, the evidence presented were not necessarily valid at the end of the day, because you know, it ended up
so
getting
the votes that were avoided were said to be unlawfully voided.
Exactly.
And they were returned back to the pool.
So what we're hearing in Kano, the 165,000 plus votes that were voided, was because according to the judgment, they were not signed, they were not stamped, they were not dated, and constitutionally that in itself makes the votes on those forms inadmissible as far as the legality of the votes is concerned. Give me your thoughts on what you understand about, you know, from the Evidence Act itself to how this can be applied in this argument.
Well, it's all a matter of what the Electoral Act provides, you know, and let me make this point. Election is about the vote, and the vote comes on the ballot. It is the ballot that you are going to count. The entire process revolves around the ballot. So the ballot is the most important item in the election. It's fundamental. That's what constitutes the numbers you are going to rely on to declare a winner. Understand? So it's the basis of it, and the ballot has to be valid. You know, cases abound where they said if the ballots are unserialized, then they are invalid. Cases are also there that they say, okay, if they are not signed, stamped and dated at the back by the presiding officer as provided for by the guidelines of INEC, they are invalid. Well, what am I saying? These are matters of fact. It is not for us here to sit down to say it is true, they were not stamped or they were not dated or whatever it is. The findings was made by the people who assessed the thing. But here is the issue. Here are the issues that are involved here. Was that case made during in the petition? Was there enough evidence adduced to establish that case? If there was enough evidence established by the parties to justify that case, the Electoral Act says the consequence is invalidation of those votes.
Right.
Those are the issues that the appellate court is going to look at.
Okay. Unfortunately, we're going to have to anchor the conversation here for now, because there is going to be around 2 of it. And as you did say, you would want to win all the way through, even if you can't win 1 or 2, perhaps win the last one that cannot be appealed any further. But then again, this is where we're going to have to end the conversation here for now. Senior Advocate of Nigeria, Samuel Kabwe, thank you very much, as always, for your invaluable contribution and analysis. We really do appreciate you for stopping by this morning.
Thank you very much.